I would now like to introduce our presenter, Alexander Gilroy. Mr. Gilroy grew up in Brandon, Manitoba, and graduated from law school at the University of Manitoba in 2015. He has been with Gray and Company since 2015 and practices primarily in the area of child protection. Mr. Gilroy appears regularly before the Court of King's Bench and the Provincial Court of Manitoba in several jurisdictions, including Winnipeg, Thompson, Norway House, and Brandon. Mr. Gilroy was also co-chair of the Manitoba Bar Association Child Protection Section from 2020 to 2022, among other board positions. We are so pleased to have him here today, and without any further ado, I will pass it over to you, Alex.
Thank you, Nina. And conveniently, that went over the biography I was just about to present, so I'll just skip right through this. Also, good afternoon, everyone. I'm going to kind of go over some very broad areas of child protection. Obviously, there's a lot more in-depth discussion to be had, but this will just kind of give you guys all a broad overview of kind of the law and how things are done. So as you can see, the purpose of this seminar is to provide an understanding of the court system, to familiarize you with legal jargon and court forms and processes, and to assist with explaining legal tests for various issues before the court. So the very first piece of legislation to discuss is the federal legislation on child protection, which came into effect in 2019. And it has two key objectives. The first one is to affirm the rights of Indigenous communities to exercise self-government and pass and enforce child and family service laws. And the second reason is for legislate national standards for providing child and family services to Indigenous children and families. Between sections 8 to 17 is the substantive content about child and family services. And this touches on various things such as priorities for placing children, emphasizing prevention when possible, what to consider when assessing the best interest of a child, and notice and participation in legal proceedings, which we'll go over today. These federal rules will apply in addition to the existing provincial or territorial laws, and most of the time both laws will apply, and the federal rules will just act as a supplement to the provincial one. If there is, however, inconsistency between the federal act and a provincial law, the federal rules will prevail. And this legislation applies all throughout Canada and the province of Manitoba. Sorry, I'm just moving my video around so I can actually see what's on the PowerPoint. And then here in Manitoba, the provincial legislation is the Child and Family Services Act, which replaced the Child Welfare Act. It's a provincial legislation, not federal legislation, so it only applies here in Manitoba. It gives various agencies legal authority to remove, or what's more commonly known as apprehend, children from their caregivers and to keep children in care. And it also establishes an administrative framework for the delivery of child and family services throughout the province. So at the beginning of the Child and Family Services Act is the Declaration of Principles, and this is found in the preamble. Couple that I just want to touch on, because there is quite a few, is the very first one listed, which is the safety, security, and well-being of children, and their best interests are fundamental responsibilities of society. So right there with the safety, security, and well-being already gives you an indication of what agencies are looking for when they apprehend a child. And also that the best interest of the child is the fundamental responsibility of society and is the ultimate test for child protection. Also at number 4 is families and children have the right to the least interference with their affairs to the extent compatible with the best interests of the children and the responsibilities of society. So again, charter rights come into effect when you apprehend a child, and parents are owed the least amount of interference with their affairs, so long as it's not putting the child in need of protection. The seventh one there, families are entitled to receive preventative and supportive services directed to preserving the family unit. So child and family service agencies are required to provide preventative measures to assist families in keeping the children in the home and not having to be forced to remove the children. At Section 8 there, families are entitled to services with respect to their cultural and linguistic heritage. So again, especially with Indigenous children, which make up the majority of children in child and family services, they're entitled to services that respect their cultural and linguistic heritage, and this is also enumerated in the Federal Act. Finally, at Part 11 there, First Nations, the Métis, and Inuit are entitled to the provision of child and family services in a manner which respects their unique status as Indigenous peoples. So again, feeding off Part 8 there, it is really emphasizing that services need to be provided in a manner which respects their various cultures' unique status as Indigenous people. So in the federal legislation, there's also its own purposes and principles, which is found at Section 8, 9, and 10. Particular interests. Hopefully you all can still hear me.
Yeah, we can still hear you.
Okay, perfect. My camera stopped working. For purposes and principles, very first principle I want to discuss is the best interest of the child. Section 9.1 of the federal legislation describes that this act is to be interpreted and administered in accordance with the principle of best interest of the child. Then it gives a broad definition of what is in the best interest of the child, and it specifically mentions that cases and decisions must consider the best interest of the child, and this includes apprehension of the child. So this broad definition is child's physical, emotional, and psychological safety, security, and well-being, as well as the importance for that child of having an ongoing relationship with his or her family and with the Indigenous group, community, or people. Then at Section 10.3 gives a number of factors to consider for the best interest of the child. I'm not going to read through all of these, but I'll just go through them somewhat slowly. But there are a lot of different principles and concepts that we've discussed earlier, and we'll discuss throughout the presentation. So in terms of the best interest of the child in the provincial legislation, this is found at Section 2, Sub 1. And there's been a recent addition to the Child and Family Services Act as of, I think, last year, July, which essentially the provincial legislation is copying the federal legislation to have the two in line. So what we just saw with the federal legislation is also referred to in the provincial legislation. So the test still is the child's physical, emotional, and psychological safety, security, and well-being as the primary test for in need of protection. But it also puts more importance on the child having an ongoing relationship with their family and also preserving the child's connection to their culture. And this is specifically important for Indigenous children. So another part of the provincial legislation worth discussing is the duty to report, which is found at Section 18 of the Child and Family Services Act. And it states where a person has information that leads the person reasonably to believe that a child is or might be in need of protection, as provided in Section 17, the person shall forthwith report the information to an agency or to a parent or guardian of the child. So some important things that are highlighted here is reasonably. So as long as you have a reasonable belief that a child is in need of protection, you have a duty to report. If it's something that is completely fictional or made up in your head or doesn't really make sense, you shouldn't be reporting that. But even if it's something as minor as you can say hear a kid screaming inside of a house and you're not sure if he's playing or not, you may have a requirement to report. Obviously, there may be other factors that apply there, but as long as you have a reasonable belief, you should be reporting. And a child is or might be in need of protection. We'll discuss what in need of protection is later, specifically at Section 17. But again, it says that a child is or might be. So as long as you have a reasonable belief, you should be reporting. So when you do report, if you do not know the parent or guardian, or reasonably believe the parent or guardian is the one to cause the child to be in need of protection, or reasonably believe the parent or guardian is unwilling or unable to protect the child in the circumstances, or reasonably believe the parent or guardian is the one abusing the child, then you must forthwith report that information to an agency. So again, another word highlighted here is forthwith, and that essentially means you do not report it in a week's time. You do not report it when it's convenient. You should be reporting it immediately and to an agency. And that is to ensure that the child gets removed from the situation which is putting them into a need of protection. This duty to report even applies to people who have acquired information through a professional relationship or through a confidential relationship. So that would include therapists, doctors, nurses, counselors, ministers or priests. They are all required to report. Lawyers, however, are not required as long if it breaches the solicitor-client confidentiality. So let's go back to that. So what's important to note here is if say a child discloses a physical assault against them to a doctor, and the physical assault was made by their father, that doctor is required to report the need of protection. The difference for a lawyer is if a lawyer has a client and they say that they physically assaulted a child in the past, and there's no indication that they are going to do it in the future, then the lawyer is under a solicitor-client confidentiality. If, however, the client says that they are going to harm a child in the near future, the lawyer can then breach the solicitor-client confidentiality, at which point they should be contacting the Law Society for guidance. I got my video back now. So professionals who do not report need of protection, they can fall under discipline under their professional association. So whether that be College of Physicians and Surgeons, Manitoba Teachers Society, RCMP, and if they do, they will be investigated by their various professional associations, and the professional association has to advise the Child and Family Services Director of the outcome of that investigation and any disciplinary action. So it is very important that you do report in need of protection, even if you are in a professional setting. So a person who does report, also known as an informant, is protected by law. They cannot be sued for libel or defamation so long as they're acting in good faith. Obviously, if say one parent is making false child protection claims against another parent in the middle of a custody battle, they're not acting in good faith and they can be sued for that. But if they have legitimate concerns about the safety of the child, they should be reporting, so long as they're acting in good faith. The identity of the person cannot be disclosed to a family of the child or to the alleged abuser. However, there is an exception to this when a matter is proceeding in a judicial proceeding. So if an informant reports to a CFS agency that they have concerns about the safety of a child, the parent or the caregiver will not be told who that informant is, but it will likely come out during disclosure and through the court process. That's usually only if it proceeds to trial. Finally, retaliation against an informant in any form is prohibited, and they are strongly protected.
Everybody has a role to play in protecting children, not just teachers, doctors, or police officers, but everybody has a responsibility to report child abuse. If you believe a child is being abused physically, sexually, or emotionally, you must report it. Call Children's Aid, the police, or crime stoppers. Call 911 if you think the child is in immediate danger. You won't get into trouble if you do it. The law will protect you. Break the silence because you could save a child's life. Break the silence because it's the right thing to do. Break the silence because it's the law.
So another important duty that's found in the Child and Family Services Act is the duty to investigate, which is found at section 18.4 sub 1 of the Child and Family Services Act, and states if an agency receives information that causes the agency to suspect a child is in need of protection, they shall immediately investigate. So if after you've reported your in need of protection concern to a CFS agency, they're also required to immediately investigate that. They cannot put it off until they deal with another case or until they get back from their lunch break. Obviously, if it's depending on the circumstances, if it's a matter of say the child is running away from home and is in gang related, it may not require immediate in the sense of they have to put down what they're doing. But if it is that a child is in a home and the parents are currently being arrested for assault, the workers should be attending to the home immediately. And they are required to investigate. That is why shall is underlined there. They need to do some form of investigation when a need of protection concern is brought to the agency. If an agency concludes that a child is in need of protection, they shall take all necessary steps to protect the child, and that will include apprehension, but it also can include providing preventative measures to avoid having to apprehend the child. And all needs to be considered within the best interest of the child. As I mentioned earlier, there's an increased focus on preventative measures prior to apprehension, even included in the definition of child and family services. And this includes services to support children and families, including prevention, early intervention, and child protection services. So in terms of an investigation that a social worker will do, when they enter into the home, an important thing to note is they're looking for, is the child in need of protection? They're going to ensure the safety and well-being of the child. They'll assess the situation as to safety risks to the child. If the worker determines if there are preventative measures, they will put those into place to avoid apprehension. And if preventive measures will not work, the worker will remove the child from the situation in their best interest. This is different from what a police officer will do when they enter into a home, as they are investigating a crime and they are collecting evidence, and they're also ensuring the safety of the worker and everybody else in the home. So in terms of in need of protection, a phrase that is often used in child protection, this is found at Section 17 of the Child and Family Services Act and is defined as where the life, health, or emotional well-being of a child is endangered by the act or omission of a person. And then at Section 17, Sub 2, it gives several examples of what is in need of protection. And these are just examples. They are not the hard and fast and exhaustive rule to what is in need of protection. And when you are investigating in need of protection, context is very important. So you should ask yourself the 5 W's of who, what, where, why, and when. Also, just a thing to note, although we'll discuss it later on, is in need of protection, it says endangered by the act or omission of a person. So obviously, in terms of endangered by the act, if a child is being physically assaulted, that is the act. However, in terms of omission, if a child is, say, being left in a very dangerous situation, say, wandering off and playing on railroad tracks without any sort of adult supervision, and the child's quite young, and the parents can see them but are doing nothing about this, this would be an omission. They are allowing the child to be in a dangerous situation and omitting any sort of action to protect the child. So the examples provided at 17.2, the very first one is where the child is without adequate care, supervision, or control. And some examples of what this would be is, say, the child left unattended. There was a case in Manitoba, this is an actual one, of a mom having CFS called on her for letting children play in the backyard while she was inside the house. This was reported in the news. Obviously, if the informant had a reasonable belief that the children were in need of protection, they have a duty to report. And CFS also has a duty to investigate once they receive that report, so they went out there. In terms of what the appropriate action in that situation is all very contextual, and the social worker is expected to investigate it and determine if there is a need of protection, or if preventative measures need to be taken, or if there is really no harm being done to the children and they're just playing in the backyard. Another example would be an improper babysitter. So a mom leaves a mentally delayed child in the care of a 13-year-old sibling while she goes to get groceries. Obviously, a 13-year-old, while they are technically allowed to babysit, a young mentally delayed child may be beyond the scope of what they are able to handle. This may not require apprehension by a CFS agency, but it may require the CFS agency to put preventative measures in there, such as respite workers or assistance with babysitting. Another example is children out late at night. So siblings are at 7-Eleven at 11 p.m. on a Friday night. Again, context is very important. Are these siblings 17 and 15? And it's really not that big of a deal, or are these children 8 and 6 and they're out at 7-Eleven late at night? And with all these examples, we're going to be required to assess the best interest of the child and what preventative measures can be taken. So the next example provided is where the child is in the care, custody, control, or charge of a person who is unable or unwilling to provide adequate care, supervision, or control of the child. So what this essentially means is, or examples of, our babysitter wants to go home and the parents are not back from where they are, and babysitter then calls all nations coordinated response and reports that they need to go home and they don't know where the parents are. So CFS will have to attend to the home and make a determination if they can find other adults to care for the children, or if they need to take the children into care while they wait for the parents to arrive back. Another example would be, say, a grandparent can no longer provide care. Say the grandma is caring for 3 of her grandchildren while the mother is in treatment. One child has cerebral palsy and is struggling to financially provide for the children. So a CFS agency may be required at that point to come in and apprehend the child, or they might be able to just assist by providing purchase orders or other preventative measures. So the next example provided is where the child is in the care, custody, control, or charge of a person whose conduct endangers or might endanger the life, health, or emotional well-being of the child. And examples of this would be the parents are intoxicated or using substances. The example I provided there of parents are having a Christmas party with friends and family who are consuming alcohol and cannabis. Children are all in the basement playing. I know that when I was growing up in Brandon, it would be quite common for all of us kids to be in the basement playing Nintendo 64 or whatever it might be, while the adults are upstairs having a Christmas party, having a few drinks. In my opinion, that's not putting the children in need of protection. However, if the situation is that there's quite a bit of people quite intoxicated to the point where they're not able to properly supervise the children, and say the children are a very young age, such as toddlers, this may turn into a situation where the children are in need of protection. Another example is parents are involved in domestic violence. These kind of situations are always a very difficult situation for CFS agencies. What is important, though, specifically for Child and Family Services, is they're set up to protect children. So if the child is witnessing domestic violence or is subject to domestic violence, it is very important for CFS agencies to become involved and to keep the child safe from that. Finally, if parents are arrested, if the mother, say, gets a DUI and gets arrested and there's no adult in the home to care for the young children, this may warrant for the children to be apprehended purely because the children are without supervision, and they will likely be returned back to the mother once she is released. But for that period where she is arrested and unable to care for the children will need to technically be put under apprehension. Then there's another example, which is a very long run-on sentence, which lawyers love to do. But essentially what it is getting at is medical care for the child, such as failing to give medicine, or failure to show up for medical or dental appointments. There's the famous Jehovah's Witness case, where parents are devout Jehovah's Witnesses and were refusing to consent to the child receiving blood transfusion, even though the child wished to receive such treatment and it would save the child's life. CFS agency had to become involved, and this went all the way to the Supreme Court. And essentially, the CFS agency was found to be able to apprehend the child and to ensure that the child received that treatment. But it is a very contested and debated issue, especially when it comes to medical care and the consent of a child or the consent of the parent. Another example is where the child, sorry, my video is just, where the child is abused or in danger of being abused. You must consider the legal definition of abuse in the Act, which the definition is an act or omission by a person where the act or omission results in physical injury to the child, emotional disability of a permanent nature in the child, or is likely to result in such a disability, or sexual exploitation with or without the child's consent. So, as I discussed earlier, the difference between an act or omission, which we'll cover a bit of examples of that. In terms of physical injury to the child, obviously a child being physically harmed by an adult is the act, but it can also include the children being in a very dangerous situation, say swimming at a young age, unsupervised. That can also result in, that would be an example of an omission. Emotional disability, this is where omission kind of comes in, where the parents aren't meeting the needs of the child, ignoring them, and essentially neglecting the child. It is important to note with the emotional disability that it has to be of a permanent nature, and it is likely to result in such a disability. If it is a one-off of the parent calling the kid a dummy for locking the keys inside the car, that's not going to be a disability of a permanent nature to fall in the definition of emotional disability. However, if the parent is consistently name-calling and picking on the child, and it causes the child to become depressed and anxious, that could fall into emotional abuse. An important thing with sexual exploitation is, regardless of the child's consent in the matter, if an adult is having a sexual relation with a child, that is still considered sexual abuse. So here's a few examples of what abuse would be, which more or less covered just now. So another example, 17.2, is where the child is beyond the control of a person who has the care, custody, control, or charge of the child. So this would be an out-of-control teenager. The child is 12 years of age and consumes substances, stays out late, and physically fights with parents. This is no fault of the parents. While the child may need to come into care and be found in need of protection, again, this is not the parent's fault. This is something that's out of their control. Another example may be that the child has emotional and behavioral disabilities that are beyond the scope of the parent's capability to handle. So in the background of this slide, you'll see my two dogs, Katie and Logan. And the next example is where a child is likely to suffer harm or injury due to the behavior, condition, domestic environment, or associations of the child or of a person having care, custody, control, or charge of the child. So what that essentially means is child is living in a home known to deal drugs, child is gang involved, or parents are gang members. So as you can see by my two dogs, they're dressed up like little hoodlums. Maybe they're gang associated in a rough crowd. Another example is where the child is subjected to aggression or sexual harassment that endangers the life, health, or emotional well-being of the child. So examples is a step-parent is abusive, child pornography, child is bullied in the home. Another example is where a child is being under the age of 12, is left unattended, and without reasonable provision being made for the supervision and safety of the child. This is essentially the latchkey kids. A 7-year-old child comes home from school at 3:45 and walks 3 blocks to their house where they watch television until the parents get home. That was my situation in Brandon. I don't think that I was in need of protection. But it may become that situation if, say, I was coming home after school and my parents weren't going to be back until 6 o'clock, and I was expected to make food for my younger sibling, and I was walking through a dangerous area of the town. Then that may become a need of protection, or it might be that the CFS agency needs to provide some preventative measures to assist the parents in keeping the children in the home and safe. Also, another example would be babysitters are too young. So a 10-year-old is looking after a 3-year-old sibling and is expected to deal with such things as changing diapers and that's far too young for a child, and will result likely in the child becoming parentified, which is not good for their psychological development. And the final example is where the child is subject or is about to become subject of an unlawful adoption under the Adoption Act or of a sale under Section 84. So this would essentially be trafficking children. And the agency would have to become involved in ensuring that the child is safe and not in a dangerous situation like being trafficked. So the Section 17, although it provides examples, this is not an exhaustive list. And the steps in determining a need of protection, you should take a look at the overarching test of where the life, health, or emotional well-being of the child is endangered by the act or omission of a person. Then consider the examples that are provided at Section 17.2. The agency is also required to review what is in the best interest of the child and the various principles that are outlined in the federal and provincial legislation. And then an agency must demonstrate that reasonable efforts were made to have the child continue to reside with the parent or the adult member of the family before apprehending. So again, this puts a positive obligation on an agency to provide preventative measures to avoid having to apprehend a child. Now, if all else fails, the child will be apprehended. And a worker, in order to apprehend, must have reasonable and probable grounds to believe a child is or may be in need of protection. Serious consideration must be given to the plan for the child prior to apprehending. Agencies are required to prove that they have made reasonable efforts to have the child remain living with the parent or another adult family member prior to apprehending. Some of these examples of reasonable efforts may include warnings to the parents, examine prospects of bringing family members into the home, in-home agency supports like respite workers, or assistance from collaterals. Immediate apprehensions are still warranted when required in Manitoba, but the agencies need to make reasonable efforts to avoid apprehension, and apprehension be the last option. So also within the federal and provincial legislation, prioritization has been put on preventative care, and that's including prenatal support and also not apprehending based on socioeconomic conditions, and requiring that agencies assist with providing financial support to a family to avoid a child being apprehended if that is the only reason that the child is being apprehended. Also discussed in the federal legislation is placement prioritization, and this is to be considered within the child's best interest. And the number one placement for a child is with the parents. The next one is with family, then with another member of the child's community, with a person from an Indigenous community to which the child does not belong, or with any other person. So an agency is required to go down this list in that order to try to determine a placement for the child if they are apprehended or removed from the home. But they also are required to consider placement with or near siblings or children of the same family in the best interest of the child. Placement decisions must take into account the customs and traditions of Indigenous peoples, such as customary adoption. And if the child does not reside with their parent or with family member, the child's attachment and emotional ties to each member of their family are to be promoted. So the court system here in Manitoba, there is 3 types of family court. There is the provincial court, which is primarily outside of Winnipeg for child protection. And they have dockets and trials in front of a provincial court judge. Then there is the King's Bench, which is province-wide. In Winnipeg, Brandon, and the Paw, there is the Associate Judges Court dockets, which are held throughout the month and often. And then trials are before a King's Bench judge in Winnipeg, Brandon, and the Paw, Flin Flon, Thompson, Dauphin, Swan River. Also, there's Indigenous courts, which are nationwide and will affect or have an effect in Manitoba. And as more communities develop their own law, none for at least a year, which is more into the development of the CFS legislation that each community may develop. Courts will be established by their communities to administer their own child protection law. So I know that Peguis First Nation has their own CFS legislation, which runs here in Manitoba, separate from the federal and provincial laws. As more Indigenous courts get formed through self-governance, we will start to see more of those appear. So in essence, this is how the courts currently are. In note, if something is appealed from King's Bench Family Division or from Provincial Court, it goes to the Manitoba Court of Appeal and then to the Supreme Court of Canada. For Indigenous governing bodies, their courts, which is found on the bottom right there, if something is appealed from that, specifically regarding charter rights, it will go to King's Bench Federal Court and then up to the Supreme Court from there. So provincial courts, dockets are held once a month, usually. Children's rights are addressed first. So when a child's over the age of 12, they're required to come to court and they will have their rights addressed first. After which dockets, the official docket begins, where parents are heard first, then legal counsel, and then default matters are heard last. Pre-trials are held if matters are contested, and you address a judge as your honor. In terms of the Associate Judges Court, this occurs in Winnipeg each day at 9:30, and Anchor has a docket on Wednesday afternoons at 2 p.m. The courtroom is almost always in courtroom 410, although sometimes that changes. You do address the associate judge as your honor. And again, children's rights are addressed first, and then lawyers proceed according to seniority. Then in terms of King's Bench, specifically in Winnipeg, if a case is contested, then it will proceed to intake court before a judge. Intake court is held every Thursday, and if the matter is not resolved at intake court, the matter proceeds to either summary judgment hearing, pretrial conference, and a trial. Trials are heard by a judge, and you address the judge as my lord if male and my lady as female. And pretrial and intake briefs must be filed 7 days in advance. These are the kind of general court forms that will be filed once a child is apprehended. A very important thing for CFS agencies, specifically in the court process, is case plans, which will outline the type of order being sought, placement of the child, any medical concerns, what the concerns with the parents are that led to the apprehension, the expectations of the parents that they will have to complete in order to be reunified with the children, what preventative measures were provided by the agency, what visits will be for the parents and the children, and what the plans for reunification are. And these case plans are reviewed by opposing lawyers and by judges. Once a child is apprehended and a petition is filed, the agency will need to serve the parents, the guardians or caregivers, and children over the age of 12 for them to attend court. Like I said, if a matter is contested, it will go to intake court and pretrial court, and the agency is expected to outline all the things that I discussed earlier. Intake court sits every Thursday with a morning docket at 9 and an afternoon docket at 2. And there are half-hour time slots for each matter. Both the worker and the parents must attend. And the judge will try to determine if the case can be settled, and if not, if there's any genuine issues for trial. And again, child protection pre-trials are very similar to intake court. The main difference is a pre-trial generally is the same as intake court in other areas other than Winnipeg and Brandon. But an intake court, after an intake court, it will go to a pre-trial, which is again very similar to intake court. And essentially at intake court and pre-trial court, there are 4 triable issues, which essentially was the child in need of protection at the time of apprehension, what is in the best interest of the child, if the child is found to be in need of protection at the time of apprehension, will they continue to be in need of protection at the time of trial, and also what is the best order under Section 38 that is in the child's best interest. Just skip this stuff. So the type of court orders that can be granted are permanent orders, which essentially means that the agency permanently becomes the guardian of the child, and the child can be placed for adoption. Temporary orders, which an agency becomes the guardian of the child for a specific time period. Supervision orders, in which a child is returned to the parents or guardian under the supervision of an agency. Alternate placement orders, which is essentially like guardianship orders, but done by an agency. Or the matter is withdrawn and the child is returned to the parents. Very recently, there's been changes to the Child and Family Services Act in which new agreements have been formed, which essentially are kinship care agreements, customary care agreements, and voluntary care agreements. And this is essentially where an agency and a parent or guardian agrees that the child will remain at a specific place for a specific duration. And it must be written down and provided to the mandating authority. Finally, there's also voluntary surrender of guardianship, which is very similar to a permanent order, but it is where essentially a parent comes to an agency and surrenders the child to that agency, saying that they can no longer care for the child. And there's very specific requirements for a voluntary surrender of guardianship to occur. I was going to include some stuff on documentation because it is pretty important, but I'm going to leave that out because I'm keeping an eye on the time and noticing we have 7 minutes left, Nia.
Yeah, we have 7 minutes left. If there's anything else that you want to go through, it doesn't seem like that many questions have come in so far. If anybody does
Well,
have questions, now's a good time to start putting them in the Q&A or the chat.
perhaps maybe I'll just start going through this documentation.
Hansen was on maternity leave for much of Chief Abagos' time with the agency, but she said as a new employee, she would need guidance, in particular on maintaining better notes.
One of the things that anyone who's been supervised by me knows, my mantra is take notes, take more notes, document, document.
Hansen's mantra may have been to document, but it has done little good to help her. Hers are among all the supervisory notes that disappeared from Phoenix's time in care, and they aren't the only missing documents. When the agency decided to close Sinclair's family file in October of 2001, it failed to make contact with Steve Sinclair to see how the single parent was managing with Phoenix. Hansen says after repeated attempts to meet with him, she sent a letter.
My understanding is that that letter cannot be found and the documentation isn't there.
Missing documents, they continue to plague this inquiry. Today, Lorna Hansen testified that without her missing supervisory notes, it's increasingly difficult to remember things that happened 12 years ago.
So what that video is from is the Phoenix Sinclair case, which is a tragic case in which a young child was subjected to quite a bit of harm and essentially fell between the cracks of the Child and Family Services agency for not being monitored and supervised and allowed to ultimately pass away at a very young age. And a very unfortunate thing in that case was documentation and record keeping by the agency was not kept up. And with high turnover of social workers in various agencies, the child was essentially looked over or missed, and it resulted in the death of a child. So record keeping and case notes are very, very, very important. There's the definition of that here in Manitoba. And there's similar definitions found in various provincial acts. Your case notes that are taken, even if you are not a social worker, but another medical professional or a lawyer or just someone who's informing an agency of a need of protection should keep good notes and should keep the originals because they may be important during court and trial. So when writing any sort of case notes that you might do, good principle or standard to go by is SOAP. I don't mean the cleaning agent, but subjective. So what you are told, what others are telling you about the situation, any objective information you receive, so what you observe and witness, assessment, analysis of the subjective and the objective information, and plan what you're going to do with the information that you receive. So in terms of case notes, put the date, time, and place, case name, factual accounts of the events, avoid opinion unless the purpose of the report is be concise. If offering an opinion, write down facts to support the opinion. Name of the maker of note. Yeah, it's just some stuff on case notes that is important, but I'll just skip over and get to the questions, and thank you.